I'd like to welcome Minister Stanton to the House to introduce this important bill here in the Seanad, and in particular to welcome the Minister given his past role as Chair of the Justice Committee, to which Senator Conway has already referred, and it was my pleasure to serve on that committee with the Minister, with the now Minister. And during the period 2011 to 2016, we did indeed produce some very important reports that, as Senator Conway has said, on issues around restorative justice, community courts, but also notably a report on penal reform in 2013, which made a number of recommendations relevant to the discussion today. So I very much welcome this bill, in keeping with a commitment to penal reform, and in keeping, I should say, with my own party's long-standing commitment to penal reform, as expressed by our party leader Brendan Howlin when he spoke in the Dáil at second stage on this bill back in 2016, when of course it was introduced as Deputy O'Callaghan's private member's bill. And I do, like others, want to pay tribute to Deputy Jim O'Callaghan for bringing this forward. It is, as I've said, long awaited and long overdue that we would see the process of parole being placed on a statutory footing, the Parole Board itself being placed on a statutory footing, and the mechanisms for deciding on parole being placed on a statutory footing. And I'm grateful to the Irish Penal Reform Trust for pointing out to us that parole has a purpose, and the main purpose of parole is to increase community safety by providing structured, supported and supervised transition of prisoners serving long sentences back into the community. A clear, transparent and fair system of parole is in the interests of all society, including victims and offenders. And that's very much the view we took on the Justice Committee in 2013, in looking, as we did, at how to adopt strategies around structured release, structured sentencing and structured release of prisoners, to ensure that sufficient and adequate means of rehabilitation would be in place for prisoners serving time, and to ensure that people were not going to be released back into the community without some sort of structure in place. And I know that that's something that for a long time our sentencing system and our prison system could be very much criticised for, was for the lack of structure, and that it's only in relatively recent times that we've seen a more structured approach to release. The sentence management practice growing up, and better legislation. And indeed, a good deal of penal reform was undertaken in the previous government. But as Deputy Howlin has pointed out, there's still room for a good deal more reform. For example, to place the prison service on an independent statutory footing, rather than retaining it as simply a division of the Department of Justice. But certainly I do see that this parole legislation is very much a step in the right direction. It, however, does not go as far as we recommended back in 2013, when we called for the introduction of a single piece of legislation to set out the basis for a structured release system, to include changes to remission, to temporary release and to parole, and to provide a statutory framework for an expanded community return programme. And I know, Minister, we were all of us on that committee were very impressed with the community return programme that we saw in operation within the prisons here in Ireland, and indeed we were very impressed with the open prison system that we saw in Finland when we did some research on Finnish penal policy. And we argued that such legislation would underpin strategies which are currently being used by groups working with offenders post-release and with potential offenders, recognising that there's some really excellent NGOs doing a lot of important work around rehabilitation, both post-release and indeed helping and assisting the prison service within prisons. So that's very important to say, that all of these recommendations are made with a view to increasing the likelihood of rehabilitation and decreasing the likelihood of reoffending, and thereby providing a service for victims, for the victims' families, and indeed for the community as a whole. So that's a very important context within which we debate this bill. I do have a procedural issue with the bill that I raised at the Order of Business Minister, and that is that, having been in the system for 3 years, as I said, Deputy Howlin and others spoke at second stage on this bill when Deputy O'Callaghan introduced it first in 2016. We now see it being rushed through the Seanad within 3 days in our last sitting week this July. This tends to happen all too frequently with justice legislation. I did say this earlier. I think it's unfortunate, because I do think it's such an important bill and so long awaited. It's a pity we didn't have longer within which to debate it. Having said that, my party are fully supportive of it, as am I, and we will facilitate its rapid progress through the Seanad. We don't intend to obstruct it, but I just want to make that procedural point, that I think it does deserve a more greater time for consideration. I do want to make some specific points about the bill, and again I'm grateful both to the Irish Penal Reform Trust, which gave us a very helpful submission, and also to Dr Diarmuid Griffin of NUI Galway, who just last year published a paper on parole, on life imprisonment and parole, called Killing Time, which is beautifully written and which I think encapsulates a lot of the issues around parole that we're debating today. I think that, as I've said, all of us working on penal reform, and indeed I hope also victims advocacy groups will very much welcome the bill for placing an existing process on a statutory footing, for giving greater clarity and certainty. And I listened to Senator O'Donnell, I think she's right about the need for clarity, for certainty, and I was grateful to her for giving us the opportunity to debate life sentences last week in the context of her bill. But of course the Parole Bill has an application and will have a future application beyond just those serving life imprisonment. And Dr Griffin reminds us that life sentences are rarely imposed and are exceptional as a punishment in a sentencing system like ours, characterised by determinacy. He gives us an interesting figure. In 2016, life sentences accounted for only 16 out of 12,163 committals to prison. So we're talking about a relatively small number of, very small number of committals, relatively small number of persons in prison. But the ultimate penalty available in a state, of course, has a social, political and cultural significance that goes beyond its use. And I think those words are very pertinent, and that's why it's very important we scrutinise the bill in detail, because while it does have an application beyond those on life sentences, clearly its most immediate application, as provided for, is to those serving indeterminate life sentences. Of course, while persons released on parole may be released from prison, they are always subject to recall, so we should remember that is genuinely a life sentence in that sense. The Penal Reform Trust point out that they have a number of concerns about aspects of the bill, and I would share those concerns. In particular, the reduction in the period at which a person is first eligible for parole, a person serving an indeterminate sentence, the increase in the sentence, I should say, from 7 years, which is currently the case, to 12. I know why that's being put in, Minister. Again, I won't oppose it, but I do think that it should be possible for those serving life sentences to be reviewed prior to the 12-year point. Not that they should necessarily be released, and we know those serving life sentences on average serve 18 years. So in fact, very few, if any, are released after 7. But the parole decision-making is a process. And again, in the interests of good sentence management, in the interests of structured release, I think it's key that persons would be preparing for over some years for what will eventually be released, and that's in the interests of victims and their families also. So I'm not sure that the absolute 12-year cutoff is essential. There are also issues around the independence of the board. Is the membership sufficiently independent of the minister, given that the members are appointed by the minister? I'm glad to see gender balance in there, and I know we'll have more time to debate this in detail at committee and report, but the final 2 points are that the minimum period of eligibility for 12 years of parole review will apply equally, it seems, to those very small number of children convicted and sentenced to indeterminate sentences. And again, that might be something that would be better amended. And finally, the role of victims in the parole process. My colleague Deputy Sherlock put down amendments in the Dáil. I'm glad to see Section 41 of the bill does incorporate the right of victims to information. We know how critical that is for so many victims and their families. So again, just to say, I welcome this bill. I look forward to making more points at committee and report stage, but I look forward to the speedy passage of the bill into law. Thank you.